Good afternoon to all participants and to you, dear panelists, and welcome to the Young Researchers Annual Conference of the European Banking Institute. Before we start with the conference, let me briefly explain what the Young Researchers Group is actually doing. We are an interdisciplinary group of young academics from different countries in Europe researching the regulation and supervision of financial institutions and financial markets. For example, the Young Researchers Group is currently working on an edited book that will be published in the EBI series by Palgrave. In addition, the Young Researchers Group organizes debates on various topics, for instance, as part of its PhD series, the virtual workshop sessions, or like today, the annual conference. Organizing such an event would not be possible without great speakers and discussants, and that is why we are very happy to have 4 excellent speakers here today. Also, we are particularly proud and grateful that 5 members of the EBI Academic Board have agreed to serve as discussants at this conference, ensuring high-quality discussions following the presentations. Likewise, we are delighted that Anna Gardella from the European Banking Authority has agreed to give the keynote speech for this conference. Ellie and I are very much looking forward to all this. The Young Researchers Group has been supported from the beginning by the entire academic board, but especially by Professors Matthias Hentjens and Christos Gortsos. Matthias is a professor at Leiden University and the secretary to the board of the EBI, and Christos is a professor at the National and Kapodistrian University of Athens and the president of the EBI Academic Board. We are very grateful for your continuous and great support, Matthias and Christos, and I would now like to hand over to you for some introductory words before we start with the keynote speech. Matthias, please, the floor is yours.
Thank you very much, Jonas, for your kind words. I hope you can hear me clearly. Thank you. Well, ladies and gentlemen, it's a pleasure to say some words at this annual conference, another installment of the Young Researchers Group. Great effort. Ladies and gentlemen, at the previous occasion, I referred to the accomplishments of the EU and the EU integration of financial law. And I said so also in the context of that specific day, which is the occasion of the where we in the Netherlands commemorate the ending of World War II. And in that context, I stressed what the EU has accomplished ever since, not only in the area of financial law, but also more broader. And sadly, today we find ourselves in very, well, less joyous circumstance, I have to say now. At this day, there is a war going on in Europe. And this may sound, and this may seem, and this may make everything else and seemingly look futile. Even conferences on technical aspects, such as what we will hear today, may look futile in that context of this war that's going on. However, I would argue that this is not the case. To the contrary. First, it is precisely international conferences like these that make people understand people from different jurisdictions. And this is what I firmly believe, that this international understanding prevents wars, even more so than treaties and formal agreements. I would even posit that if the leadership of the countries that now are now engaged in the war would have been a member of the Young Researchers Group and have met at conferences like these, this all would not have happened. Second, the topics of this afternoon's conference are no mere technicalities. These are important topics that concern core issues of our present-day societies. And this is also exemplified, for instance, by the sanctions that have now been discussed on the international level. And the EU has even considered that, you know, the most far-reaching sanction shutting off, and this concerns financial law, shutting off SWIFT, that this is now too drastic even at this very moment. So this is an example, I think, of the importance of financial law, of tech, at what seemingly are technical topics that we are discussing today. So in conclusion, there is even a bigger reason to hold conferences like these, especially in this time of war that is going on. I am certain that conferences such as the one we're having today will contribute to better lives for people instead of destroying them. And this may all sound a bit pompous, I'm aware of that. And if you can reproach me for that, you're probably right. As a counterweight, I may add that the Young Researchers Group is also about having fun, and I'm confident that we all will have big fun in today's conference, as we have always had in conferences such as the organized by the Young Researchers Group. So, ladies and gentlemen, these were my opening remarks. I wish you a lot of fun today and a lot of inspiration of today's conference. And with that, I gladly hand back to you, Jonas.
Thank you very much for these words. Christos, would you also like to address some opening remarks?
Thank you very much, dear Jonas, and thank you for your kind words at the beginning. It is always with pleasure within the academic board when we discuss about the achievements of the Young Researchers Group over all these years. You are the third chair of this group, and you have managed, together with Ellie, to keep the level of the Young Researchers Group as high as it started when Agnieszka was the first chair, and at an initiative taken, among others, by Matthias, who has been assigned the task of overseeing on behalf of the academic board this group. I would share the concerns raised by Matthias before. This conference today is following one, the Global Annual Conference of the EBI, which has taken place yesterday and today in the morning. And to be honest, yesterday at around 3 o'clock, when it would start Athens time, we were concerned whether we should allow this conference to take place. And we were encouraged by the fact, we took the decision to go on, and we were encouraged by the fact that at the peak we had 80 people attending, meaning that it's not business as usual, but again, under extraordinary conditions. We have a war in Europe, as Matthias mentioned, yeah. We still need to keep our thoughts not only to the victims of this war, but also to our interests, yeah. And the more we hold conferences of high quality, like the one that you have organized today, the better we will be equipped, yeah, to continue the idea of further integrating the European Union to the extent that we wish. With these words, thank you again for having set up this conference. Particular thanks to all of my colleagues, Matthias Lehmann, Michele Siri, and then also I think Filippo will join us, yeah, Annunziata, who have kindly accepted to participate in this. They are the experts in the papers which they are going to comment on, and most of all to Anna Gardella, who has accepted to give the keynote speech. I stop it here and I take my notes now from what I will hear from Anna. Thank you very much, Anna, for having joined us.
Thank you, Christos. Thank you, Jonas and Matthias and everybody. So I think I don't want to take too long, but I think it's opportune to say a few words on the current situation in Ukraine. and reason about Europe, whether we can celebrate half success in financial integration, and I will clarify later why half. But it's again time to think whether Europe is fit for purpose against face to current challenges. Europe as united has showed increased union against the pandemic, has showed some political unity in the last few weeks, but clearly it shows a great deficiency, the lack of an army, and the sort of and the intention to fight a war with economic sanctions. Let's see. I think this is something that will need to be, it's not for this conference, it's not probably for us, but this is the common defense and foreign policy comes to the fore again, and with more and more pressure. However, the topic of this conference is another one, so I will shift to the topic of the conference, which is, I thought of, it's the beginning of the year, more or less, till February, and we can have an overview of recent regulatory and policy developments in banking regulation. So there are a lot of fancy topics, digital finance, sustainable finance, but there is also the Crd6 proposal and the ever-lasting outstanding issue about completion of the banking union. So maybe we can start with some good news, some uplifting into, let's say, well, we consider at least good news that the ESAs have recently published 2 weeks ago the call for advice on digital finance to the Commission, where we have provided some recommendation on a number of topics. I think without going through the whole paper, I think there are a few that deserve particular attention. The first is the suggestion to create a sort of intermediate holding company under which the financial services company, under which should be the companies, the undertakings, providing financial services. So sorry, I say I try it again. So with regard to big techs, the report monitors that there is some increase in access to financial markets. Some directly via the adoption of payment institutions authorization, some in connection, in tandem, let's say, in synergy with other smaller payment service providers or credit consumer undertaking. The trend outside Europe is more marked, especially in Eastern Asian countries, where there is there are more synergies, and they are more advanced in these synergies between big techs and payment services and fintechs. And so what we have recommended first is when entities other than supervised entities do provide financial services, to create an intermediate holding company under which all the financial services provider are controlled, so that sort of a new consolidation perimeter can be created and be supervised by the supervisor and be subject to regulatory requirements. Another recommendation that I think it's relevant because it really shows, again, in reference to big techs or new players other than supervised entities accessing the financial markets, is the suggestion to create colleges for those operating cross-border, but also those operating domestically, composed not just of supervisors, but where competition authorities, representatives of the competition authorities, and representatives of data protection authorities should be present. And I think this is a very relevant acknowledgement that on the operating models of the new players entering the market. There is still another piece of, so I think that for the digital finance, the call for advice on digital finance, I will just care to point to these two main aspects, but there are some others. There is the last bit of the call for advice on digital finance that is upcoming and will be published at the end of March about non-bank lending. It's a report that is being conducted by the EBA, and so alone, not together with the other ISAs, and that monitors whether new or fintech players do provide financing without being banks. I can anticipate that, again, the phenomenon is not particularly significant in the EU, but maybe there are some fine-tunings to increase consumer protection that need to be implemented. And I will now move to, I think, a big, what I consider an important development at EU level and brought about by the Crd6 proposal, which is the proposal on the third country branches, which completes the regime on intermediate parent undertakings. And that basically it's an acknowledgement by the EU that it has to take a uniform approach about how a third country group can and should operate within the EU. The proposals on the access, regulation and supervision on third country branches are largely inspired by a report of the BA published in June. And there are some additions, for instance, the prohibition of direct provision of services from third countries, which is, you may have read in the newspapers, is raising some criticism by third country operators. And so we'll see. What is important from the EBA perspective is not just to have rules on the third country branches And we appreciate that the Commission has taken a proportionate approach with division in classes of branches depending on the volume of activities, the origin of the third country of establishment, so the sort of a risk approach. But what is important to us is to have a comprehensive view of the activities that entities belonging to the same third country group carry out in the Union. And therefore, we are considering the branches in close connection with the IPU monitoring threshold, with the strengthening of cooperation among EU authorities to monitor and exchange information relating to the entities belonging to the whole group, so investment firms, third country branches, subsidiaries, in order to have a global perspective and to understand to what where the risk lie and how we should tackle them. It's more still a sort of studying approach. But I think it's important to have this overall view and that may be further tailored, and also to have this view compared and compare it to the approaches taken in other foreign countries to maintain competitiveness. So I think this concept of dealing and focusing on access to the EU market from third countries is a new concept and which is under the radar. Moving now to another, I'm doing just an overview at 15 minutes. So this is something new, which is good. I think where the additional efforts need to be made is in deepening the integration of the EU financial banking market. This may be also called completion of the banking union, but given that completion of the banking union is a difficult term to use because of political obstacles related to EDIS, we may use another terminology and talk about market integration, which is a bit the other side of the same coin. You may have EDIS if you have a fully integrated and sort of single jurisdiction, a fully integrated regulation and supervision. So we regret to see that the Crd6 proposal and CRR3 proposal do not move ahead on the issues of prudential waivers, on intergroup financial support agreement, and that therefore these aspects of cross-border operations and consolidation across EU are still not tackled at EU level, and regulation is uniform but still channeled across national borders. There is a need of an authentic group-wide regulation. I cannot disclose further, but we are trying to keep the topic alive within our groups. Clearly, there are very political sensitive sensitivities, but we still are hopeful that bit by bit, with progress in the resolution framework and practice by reaching the steady state with MREL and increased confidence with the operationalization of the resolution strategies. In particular, the host authorities will receive more and more reassurances about the well-functioning of the banking union, and this hopefully may lead to also tackling the topic of increased market integration.
The title is Facing Uncertainty, Intergroup Financing in a Crisis, and I think uncertainty is something we can all relate to at the present moment with the political circumstances. Unfortunately, being someone from Russia, I can relate to that very well. And of course, it's not only political uncertainty, but also a lot of uncertainty for businesses at the moment. But I'll specifically focus on financial support between enterprise group members in a situation of crisis. And I will start by explaining what I see as the problem. Sorry. So I'll start with the problem statements, and the problem is, of course, the uncertainty of the current regulation when it comes to the transactions that are allowed and that are value creating and those that are damaging or opportunistic. And then I'll look at three regulatory strategies to address the uncertainty. First being the substantive ex post review of transactions and the fact to what extent the group considerations and the synergies and group economic reality can be taken into account when looking at transactions between group entities. The second strategy is the ex ante authorization of financial transactions, so-called restructuring privilege or safe harbor. And the last strategy will be the preemptive intergroup support arrangements, which are prevalent among credit institutions. So just to point out, even though I will talk about banking groups at the end of my presentation, it is more broadly the intergroup support that I'm looking at, because very often, of course, banks will be subject to national insolvency law rules, which often have rules related to transaction avoidance. So I think this is also relevant for financial institutions. Well, the problem is that modern enterprises operate as interconnected groups of companies, which are characterized by elaborate networks of intercompany financial arrangements. There are synergies. There are also interdependencies that are created by the existence of these financial arrangements. And Lehman Brothers, of course, is a good example of such an integrated enterprise. When the parent company filed for bankruptcy in September 2008, we all saw what consequences followed from that, and also from the centralized cash management system that was implemented by Lehman Brothers. And intergroup transactions affect the position of creditors and other stakeholders of group entities. So for instance, if one group entity acts as a lender, a guarantor, or a collateral provider, and then ends up in bankruptcy, these transactions may be damaging to the value that is available for creditors of this entity, and therefore creditors will suffer. Another issue is that in the vicinity of insolvencies or financial distress, directors and shareholders may engage in various opportunistic transactions. So they may decide, for instance, to shift value or to strip the assets from one entity for the benefit of another entity, therefore damaging the interest of one of the group entities. So I call it a group opportunism. But at the same time, intergroup transactions may and do facilitate efficient allocation of capital within the group, support operational continuity of group entities, and preserve going concern value. So it is recognized that efficient transaction between group entities can promote value creation and can allow preservation of going concern value. So I'll talk about banking operating companies. So the idea is to allow them to have sufficient liquidity so that they can continue their operation without any stops. And so the value creation and efficiency is the other side of the spectrum, as opposed to a group opportunism. So the question was how do we structure regulation in a way that will promote value creation, but at the same time allow us to avoid this damaging and group opportunistic behavior. And as I said, I look at various strategies. On this slide, you can see I've divided them into exposed strategies and ex-ante strategies. Exposed strategy is the review of transactions exposed, usually done by courts in insolvency proceedings. And then on the other hand, we see ex-ante strategies. So the most basic one, I guess, is the prohibition of certain transactions. See in the US, for instance, after the WorldCom and Enron legislation was implemented that prohibits listed companies to extend loans to their offices. That's a very clear example. We just prohibit, but of course, as I said, it's not a good idea to prohibit all transactions between group entities because some of them may be value creating. And then the three other strategies have already been mentioned. The ex-ante authorization, so you go to court, you get an approval of a transaction, and then you actually implement or execute the transaction. The proposition of resources in separate entities, so you make sure that enough resources are placed in the entities. So here we see capital liquidity requirements, but also internal and external MREL. So all of them are targeted to in making sure that there are sufficient resources placed in the entities to ensure their non-interrupted operation. And then finally, preemptive support agreements. So the group financial support agreements available under the BRD, but also I look into the practices in the United States. And if we look at the resolution plans of major banks in the US, we see that security support agreements, intermediate holding companies, already mentioned by Anna, but the US equivalent of these are prevalent in the US. And we'll look at them at the end of today's presentation. To start with the exposed substantive review of transactions. So these transactions avoidance rules, which are found in bankruptcy and insolvency laws of EU member states, aim at preservation of assets of value within the companies, but also at ensuring equal treatment of creditors. And there are, broadly speaking, three different types of categories of such transactions that are avoidable under national laws: preferences, transactions at an undervalue, intentionally fraudulent transactions. And here you can see on the right hand the book that was published just a few weeks ago by Reinhard Borg and Michael Feder, who have done the analysis of transaction avoidance laws of the EU member states. So currently the European Commission is considering harmonization of national insolvency law rules, and part of that trend is harmonization of transactions avoidance rules, but those are largely unharmonized at the moment, which creates legal uncertainty. And what I would like to point out in this respect is what the UNCITRAL has said in the legislative guide, that some transactions that might appear to be preferential or undervalued as between the immediate parties might be considered differently when viewed in the broader context of an enterprise group. So the group context may affect the considerations and the evaluation of transactions between related parties within an enterprise group. So I call this group considerations in transaction avoidance. So first of my research of this paper looks into laws of the UK, US, and the Netherlands to see whether group considerations are indeed a part of the evaluation that courts are engaged in when looking at the transactions. And I come to the conclusions that determining the reasonable equivalent value, let's say, of the benefits that arise from such transactions as, for instance, intercompany guarantees is very problematic and difficult. Because, for instance, one entity provides guarantee for the benefit of another entity within the group. So does that entity receive value or benefit from that transaction? So really hard. And so I look at the cases and laws and come to the conclusion that we see a lot of uncertainty and lack of predictability. So uncertainty comes here as one of the problems. There's, of course, the problem of hindsight and outcome biases. And ultimately, it is a fact or fact-intense analysis. So you really have to pay attention to various circumstances surrounding the transactions to determine whether this transaction is a transaction at an undervalue, for instance. And here I also list some of the general observations that I come up with. You know, what do courts look into specifically when deciding on whether a transaction is avoidable or not under national law. But I'd rather move to the next slide and cover other strategies, because I know I only have 15 minutes. So the second strategy is the authorization of a transaction. So instead of looking at and evaluating transaction ex post, we look at it or do the screening process ex ante. So something called safe harbor. And there are different types of safe harbors, and I just list some of them because it's important to be clear what we mean by a safe harbor. Some transactions may be carved out from otherwise applicable legislation, and here is an example from the US Bankruptcy Code, effectively granting immunity to certain financial transactions from transaction avoidance, or as they're called in the US, fraudulent transfer, fraudulent conveyance legislation. The second type of a safe harbor protects directors from liability. We see that in Australia. In 2017, the special framework for safe harbor was introduced there, but I'm mostly interested in the last type of a safe harbor, which is an approval mechanism that establishes the screening or authorization of a transaction and therefore grants immunity from transaction avoidance rules. And we see this type of a safe harbor implemented in the Netherlands as part of the WOA, as part of the legislation that was introduced quite recently to promote restructuring of viable enterprises. So effectively, it allows a company to receive an approval from a court to a certain transaction or a certain legal act. And once that transaction is approved, it cannot be challenged ex post in case of a bankruptcy. But I see a problem with that as well. And I see that there's still uncertainty out there. So imagine we have a group consisting of a group A as a principal debtor and group B as a guarantor, and the bank lends money to company A. And as part of this financial arrangement, company B provides a guarantee or collateral to the bank. And the court presiding over the proceeding against a principal debtor, so against company A, grants authorization. So what I do in my paper, I really look into whether the guarantee being a part of the package of this financing will also be protected against transaction avoidance. And I come to the conclusion that I think it's not protected. We don't know, but there's uncertainty there. Just pointing out that uncertainty comes back as part of this second strategy as well. And of course, nobody likes uncertainty. Uncertainty increases transaction costs. It's bad for business, so everybody wants to have legal certainty, but I argue that, again, in this second type of strategy, uncertainty is not achievable, at least the way Dutch legislation is phrased at the moment. And then the final part, which I think is maybe more interesting in light of the discussion that we have in the EBI, is the preemptive financial arrangements in banks and banking groups. So after the financial crisis in the area of bank resolution, attention of legislators in the US, but also in the EU, has shifted from the reactive mode of preemptive, from the reactive mode to preemptive and proactive mode. So now we look into crisis preparation rather than a crisis response. And this shift has also been reflected in the way intergroup support and intergroup obligations are prearranged or prepositioned within banking groups. The goal is to ensure that sufficient capital and liquidity are available to banking subsidiaries, to operating companies in a crisis situation, so that such companies can continue offering services without any interruption. And there are three mechanisms that I look into in my paper, namely group financial support agreements under the BRD, prepositioning of resources in bank subsidiaries, so internal and relevant TLAC, and establishment of special contractual arrangements such as secured support agreements. So this is something we see as being the major way of dealing with intergroup support in the United States. And the first strategy is group financial support agreements, a very interesting mechanism. So there's a whole chapter in the BRD devoted to this group financial support agreements, heavily discussed at the time when the BRD was proposed. There was a public consultation. It's a very interesting mechanism, but the problem with this mechanism is that it's not being really used by banks in the EU. It is a preemptive transaction, so it doesn't entail the immediate transfer of capital. Right? So, but once approved, its execution should not be inhibited by any legal impediments in national law. So it is a sort of a safe harbor, but it needs to be approved and it needs to be executed. And the whole procedure for the approval and for the execution is quite cumbersome and quite complex. And you can also say it's quite rigid, because it is ultimately dependent on the state authorities whether they would be opposed to the execution of such agreements. So after all, banks are not required to enter into these agreements, and in fact they're not really keen, so they're not entering into these agreements. So what the BRD wanted to offer them as the tool actually is not being used, and it just shows that maybe something is wrong with it. And I'll move to the second strategy, which is prepositioning of resources within banking groups. So the aim, as I said, is to guarantee sufficient loss absorbing and recapitalization capacity available in resolution. And of course, we have rules on internal MREL, which should provide for this internal recapitalization within banking groups, but I see problems with that as well. One problem is that the prepositioning leads to the fragmentation of resources within the group. So whereas it may be more efficient to allow for the transfer of certain capital from one group entity to another, because there may be idiosyncratic crises that affect specific entities, specific member states. So I call it misallocation. So you may end up with a misallocation of these resources. And the second one, there's no guarantee that the preposition resources will be sufficient in case of a crisis. And while there are no rules that actually mandate transfer of liquidity, for instance, from the parent to the subsidiary. So after all, we may end up in a situation where the problem is there, but the solution is not. And the final arrangement, which I found quite an interesting one, is these structural arrangements and intergroup support transactions that are prevalent in the US. So they give more flexibility to the group to allocate liquidity and capital within the group, but they make sure that there are sufficient legal instruments that actually can be executed and can mandate the provision of support. And these are called secured support arrangements that are prevalent among US banks. So if you read the resolution plans of JP Morgan or Citi, you will see that all of them have those arrangements under which before the parent company files for bankruptcy, so Chapter 11, it undertakes to downstream capital to the and the remaining assets to the intermediate holding company, which is itself contractually obliged to provide support to the key operating entities. So there is a layer that is created specifically to allow for the better regulation and for more flexibility in the way the unallocated funds can be transferred to specific entities within the group. And just like the group financial support agreements under the BRD, these SSAs, security support arrangements, have not been tested by a major financial crisis. So whether they work, I guess it's hard to say because we don't know for sure. And with this, I would like to end with a few concluding remarks by saying that in the realm of group insolvencies, there are many possibilities, but very few certainties. This is also true for rules concerning intergroup financing. So as I said, looking at different strategies from the private and public law perspective, from non-financial companies, but also from financial institutions, we see that there's a lot of uncertainty there, which is not necessarily good. Different strategies may be adopted to promote efficient intragroup financial support, ranging from ex-post review, substantive review of transactions, to ex-ante authorization and to preemptive strategies. And maybe each strategy, because it has its pros and cons, they're together, the availability of these strategies may provide a better response to the complexities of group insolvencies and group financial arrangements. And because groups are different, right? So maybe it's good to have many different strategies available to be more fit for specific group structures. And with this, I would like to finish my presentation. Not sure if I've managed within 15 minutes, but thank you very much.
So thanks for having me. I have to say, I have to echo most of the remarks that were made, right? It's a difficult day to talk about stable coins or to infragroup financial support or things of this sort. And there's not even much to add to that, right? I think in what at least this situation reminds me is that what we do is relevant, and doing well what we do is relevant, and we should keep in mind that what we do, especially in academia, is to build a better world, is to build a world that is at least marginally more just, and not only to solve legal or financial problems. I think is something that calls us on rediscovering the purpose of what we do. There's of course no silver lining here, but I think is something we should keep in mind. Yeah, having said that, this is a very early stage project. It's an idea I had some months ago, and then I was lazy and I didn't wrote it. And then when I took it back, I discovered that Gary Gorton wrote something very similar on the US. On the bright side, Gary Gorton is a famous financial economist at Yale, so he's not my competitor. I think I can safely write the paper and publish somewhere that Gary Gorton will never put his eyes on. Compared to what he does, I put more low, in the sense that he also looks at the liquidity risk that stablecoin entails. So what I do in addition to his paper is to try to understand the legal underpinnings of this liquidity risk, and then focus on EU law. That is, of course, what I'm mainly interested and knowledgeable in. So what I will do is to introduce a little bit my framework, to share the idea I have in mind. That may take the big chunk of the presentation, and then I will briefly go through the proposed European regulation, and that we may take that more into account in the Q&A. So my first approach to fintech, blockchain, and things of this sort is very skeptical. So there are these refrains and mottos that claim that we are in front of unprecedented revolution and nothing will be the same anymore, especially when it comes to financial intermediation versus financial disintermediation. I have a very critical approach and a very critical stand to this type of statement, and I'm not pretty sure we are talking about disintermediation and decentralization, rather about re-intermediation. So trying to substitute old intermediaries with new intermediaries that may pose more or less risk, and they may pose different risks that we didn't take into account before, but also old risks that we know about and that are reshuffled and reshaped into new technologies. So the thing I am trying to say is that much of what we see going on especially in the blockchain debate and on stablecoin, that is the topic of this presentation, is something we have already experienced, at least in equivalent ways. So the point I want to put forward, that is the main point of this presentation, is that stable coins are private money, and private money is nothing new. We have been dealing, both economists and non-lawyers, have been dealing with private money for centuries. There's a very good paper by Dan Overy, it's called Bad Money, I think, that kind of, even from an historical perspective, disentangles what is good, meaning stable and sustainable, creation of private money, and what is bad, creation of private money. Issuing bank deposit is creating private money. That is good private money because there's a whole set of legal institutions, both private law institutions and regulatory law institutions, that make it good money. So deposit insurance, fiscal backstop, access to central bank facility, and so on and so forth. There's also plenty of very unsuccessful story of creation of private money. The money market fund industry that started in the US in the 70s and then came to Europe, and is basically an industry that is based on regulatory arbitrage, is a very poor example of creation of private money, where you do create private money outside of the regulated sector, and when things go wrong, as they did go wrong in the global financial crisis, you collapse and you create systemic externalities. So the other main point I want to put forward here is that stablecoin as a construction has very many functional similarities to money market funds, very many more than we could expect at a first sight. And by the principle, same business, same regulation, I would argue that the post-crisis regulation of money market fund is one of the most successful stories of post-crisis regulation, at least in Europe and at least for short-term money market fund. And we should learn from that. And my argument is that MiCA is not doing that, is focusing on something slightly different. So after this broad presentation, let me go briefly into the details. And Ellie, if I go over time, please feel free to interrupt me and stop me. Give me a minute.
No worries, Eduardo. Of course.
So liquidity risk is something that especially people with a purely legal background really struggle to understand. I mean, and I can say safely that because I have a legal background and it took quite some time to understand what liquidity risk is. So financial systems, and we know that, are fragile by design. We know that from Minsky, we have been reminded, Gary Gortsos did it a lot of time, and more plastically, the global financial crisis did. Liquidity is a lot of things. So you can think of market liquidity, how liquid the market is, how easy it is to raise fund in the market. You can think of funding liquidity. So how easy is to attract short-term funding in the market. One insists, if you have in mind a sketch balance sheet of a financial institution, one looks at the liability side, so raising short-term funds. One looks at the asset side, so liquidating assets. And the interesting characteristic that was not foreseen before the global financial crisis is that these two types of liquidity, when everything goes well, is fantastic, and we think that liquidity is infinite. But when liquidity dries up, so when uncertainty starts to be in the market, those two illiquidity reinforce one another. It's more difficult to attract short-term funding, and it's more difficult to sell the assets. And this creates solvency problem, and I think the paper by Brunnermeier is a good read on that. This is one of the standard rationale for bank regulation, and this is a financial framework. The second step of what I'm doing is to claim that this financial construction, is largely a function of legal entitlements. I mainly build on the work of Katharina Pistor. You may know her. She wrote probably, in my humble opinion, the most influential legal book of the last decade, Code of Capital. Everybody should read that at the first year of law school. So the claim is that legal entitlement, especially legal entitlement provided by private law, shape distribution of wealth, but also financial stability risk. If you want to promise liquidity, that is what creators of private money do. You create private money, and private money means that everybody accepts that money for their face value. So the share of one share of a money market fund is worth $1 at any time, and you know you can redeem that share at any time. That is the money-like feature of money market funds, and functionally similar is with bank deposit. They can promise liquidity, they can promise securities because of legal entitlement. It's all contracts and contracts enforcement and allocation of property rights. In banking, so if for financial institutions that have a banking license, this is coupled by a backstop provision that is, of course, deposit insurance and then backstop by a fiscal authority. This is not only a legal issue. This legal construction makes your promise of liquidity credible. And that's key. It's key because so long as the promise of liquidity is credible, people will accept it. But when it becomes not credible anymore, someone will need to take losses. Whether people that have private money, so think of the example of the free banking period in the US, where free banks issued private money that at a certain point simply were worthless, so they took losses, or society take losses through bailouts. There's literally no alternative there. And one point I want to stress is that strong legal entitlements are procyclical. This goes against the starting hypothesis of the law and finance literature. So some of you may be familiar with that, this famous Laporta, Schleifer, Wisny papers, where the idea was that the stronger the investor protection, the stronger the financial development, which can be true. It has been proven wrong in some instances, but the intuition is great, especially not in the financial sector. When you have a more dynamic framework in mind, where growth and contraction is cyclical, strong legal entitlements make the system much more rigid, and you can't adjust when you need to adjust, because people have strong legal entitlement that they can exercise at any time. And for instance, in the global financial crisis, the bankruptcy safe harbor for financial collateral was a disaster, whereas in good time, the bankruptcy safe harbor for financial collateral foster financial development. So we have these two elements, one financial, one purely financial. Liquidity can dry up and create solvency problem. On the other hand, we have a legal framework, legal institutions that support the liquidity promises of the creator of private money. This legal framework is largely the ability of promise this liquidity is largely a framework, a function of this legal framework. And a legal framework is not neutral. A legal framework is created by lawmakers that have some regulatory goals in mind. And what I depict here, I don't call it trilemma because so many people call the trilemma other trilemmas. I just said trade-off in a much more humble phrasing of it. But what it seems to me is that MiCA, Marketing Crypto Asset Regulation Proposal, has in mind three goals. That is to foster innovation. I mean, it's not what it seems to me. It's written in the preamble. To foster innovation, to protect market, to protect market integrity and investor protection. And I put these in the same bucket because in my framework of strong legal entitlement, there's a big correlation between the two, and to preserve financial stability. So fostering innovation is the part where stablecoin DLT comes. Preserving financial stability is being sure to be prepared to withstand shocks in liquidity. Protecting investors, like it or not, is providing them with strong legal entitlement, whether to have information or to realize their claim. I'm going over time. I'm cutting down. Yes.
Thank you, Eduardo. If we can conclude like in a very few minutes, that would be great, because I see also some question on the chat.
Fantastic. This is the framework, and my claim is that you can't achieve all of these at the same time. So let me just introduce stablecoin. Stablecoin is exactly a way to create private money by issuing tokens and guaranteeing the stability of the value of those tokens with some backing. It can be algorithmic or asset linked. Let's focus on the asset link part because we understand it better, and because now they are the most advanced at this moment. Yeah, the traditional critiques are mainly on the financial on the monetary policy side and on the investor protection side. and I indeed add this liquidity risk layer. So from this perspective, the three key elements of stable coins are: first, there is a currency that or a basket of assets which is pegged by this stable coin. So usually it's US dollars. So one coin is worth $1. That is again very similar to what money market fund used to do. This promise is backed by some research, and the quality of this research is key, and what you can do with this research is key. Three, you promise stability and liquidity. So you promise redeemability at par, which is a legal entitlement to the holders of the coins. Is this credible? And if it is not credible, who bears the shock? This is the example of Tether. So this has been proven to be stable. Tether, in my humble opinion, is laughable, is not backed. I mean, it's not my humble opinion, is a New York judge said that is not backed, not even close to 100% is backed by reserves, but people still believe in it. There is something that I find quite scary, that is the idea in the crypto world that stable coin are a safe asset during volatile moments in the crypto market. This is very scary. So far it has withstand, but if things scale up, I'm very scared by this idea because it can create panic and it can reverberate in the real economy. So here there are some examples of private money, and money market fund is one of those. So let me just get to MiCA. So what I am skeptical about is that MiCA aims at regulating stablecoin in two ways. They can be asset reference token or e-money token. Asset reference token to be kind of in a superficial way are slightly less regulated. E-money token are a bit more regulated. And the idea is that this regulation closely resembles the regulation of investment funds that aim at protecting investors and aim at fostering innovation. The provisions that try to preserve financial stability and especially liquidity risk are at best underdeveloped. This is so those are the own funds requirement that is pretty low, and the redemption rights that is the most problematic according to me. So you have a legal entitlement to redemption, and that is sanctioned by law if you have a license, and the obligation on reserves that are pretty loose. There's some difference on e-money tokens, but it is a bit it's marginal. So e-money tokens are safer than asset reference token. The problem is who wants to issue e-money token? I wouldn't know. And so these are different ways to set this trade-off. But I can get to the conclusions, or at least preliminary conclusions. If you buy my framework, that is based on liquidity risk and the legal entitlement that creates this liquidity risk, the current MiCA proposal is not good to preserve financial stability. As simple as that. It will be good to preserve financial stability so long as liquidity is in the market, but liquidity is in the market so long as you don't need liquidity, and by you I mean society. Market players need liquidity all the time, but society needs liquidity exactly in times of distress, and the foreseen framework, the foreseen regulation of crypto asset is not providing for credible liquidity in times of distress. To the contrary, focus is much more on market integrity and investor protection and fostering innovation, and leaves financial stability a bit behind. So the proposal I have in mind is to fine-tune the MiCA with the 2017 money market fund regulation. And money market funds are regulated differently, but I would like to target constant net asset value money market fund that are the ones that are indeed functionally similar to stablecoin.
My name is Maria Domina. I'm assistant professor in business law at the University of Lorraine in France. And otherwise, I'm originally from Ukraine. So perhaps all of you know it's a very difficult time for my country. But I hope the situation will ameliorate very quickly. So today I'd like to present you my research on the soft law powers of the European Banking Authority. And the title that I propose for this presentation is the following: Do means justify the results. So let's now move to the next slide, please. As you know, perhaps European Banking Authority was established in 2010 after financial crisis of 2007-2008, with an objective to ensure consistent, efficient, and effective supervisory practices within the European system of financial supervision. And in order to achieve this objective, European Banking Authority may issue different soft law instruments such as guidelines and recommendations. And as all of us know, soft law instruments are not binding, meaning that member states are not obliged to implement them, contrary to hard law instruments. So now let's move to the next slide. The objective of my presentation is actually to talk to you about a recent case that was judged by the European Court of Justice on 15th of July 2021. And this case involved French Banking Federation and French Authority of Prudential Control and Resolution. This case concerns guidelines of the European Banking Authority issued on the 22nd March 2016 on product oversight and governance arrangements for retail banking products. And for the sake of simplicity in my presentation, I will refer to this document simply as guidelines. Let's now move to the next slide. And I'd like just to provide you with a quick factual background of the case. So the above mentioned guidelines, they have several problematic points, but the most problematic one is that they actually import the concept of product governance, a concept that applies to financial products under the MiFID II, to retail banking products, such as accounts, payment services, mortgage credit, and other retail banking products. On 8 September 2017, the French Authority of Prudential Control and Resolution has declared on its website that it will comply with these guidelines. This authority also stated that the guidelines are to be applicable to credit, payment, and electronic money institutions under its supervisions. Moreover, these institutions had to make every effort to comply with these guidelines and to also ensure that their distributors complied with them. So here we can make a conclusion that once the French Authority of Prudential Control and Regulation said that it will comply with this instrument of soft law, it became thus binding on the concerned financial institutions. Now let's move to the next slide, please. The French Banking Federation, it's an association organization that represents the interests of all French banks, decided to contest the validity of the guidelines by bringing a claim before the Council of State's French High Administrative Court. According to the French Banking Federation, European Banking Authority did not have competence to issue such guidelines because they were too restrictive for French credit institutions. I will provide you with the arguments of the French Banking Federation. First of all, the concept of product governance and target markets, as well as the distinction between manufacturers and distributors that were introduced in the guidelines, are not mentioned in any of the regulation or directives that set out the scope of the power of European Banking Authority. Conversely, these concepts are indeed used in MiFID II in relation to the product governance of financial instruments placed on the market by investment services providers. So now we can move to the next slide. As such, according to the Federation of French Banking Federation, because these guidelines apply or import the concepts and notions that relate to the governance of financial products to the governance of retail banking products placed on market by credit institutions, products whose risk for consumers are much lower, the European Banking Authority is imposing thereby on manufacturers of retail banking products compliance with the conduct practices that are too stringent and are not justified. In addition, these obligations are not based on any instrument of European law whose application throughout the European Union can be clarified by the European Banking Authority. As such, in adopting these guidelines, the European Banking Authority exceeded the scope of its powers as set forth in the regulation on European Banking Authority. Now we can move to the next slide, and I would like to present you a very interesting position of the French Council of State. In this case, French Council of State followed the principle established by the Fair West case law, so it's a national case law. According to this principle, it is possible to bring an action for annulment of those soft law instruments that create legal effects. According to French law, then, the French Banking Federation can invoke the invalidity of the guidelines. For what reason? Well, for a very simple reason, because according to the French Council of State, the compliance of the Authority of Prudential Control and Regulation with the guidelines will have a significant impact on the operations of financial institutions, as they will have to adapt their practices regarding governance and supervision of retail banking products. So I just want to stress a very important difference in approach of difference in the approach between European Union law and French law. As we know, in European law, we make a distinction between those instruments that have a mandatory nature and those instruments that are of a soft nature, meaning the compliance with them is non-mandatory. Whereas in French law, there is a second level of comparison between those instruments that create legal effects and other instruments that do not create legal effects. So this is something quite important, and I will come back to it later in my analysis of the approach of the European Court of Justice to this decision. So now we can move, please, to the next slide. Before deciding this case on its merits, the Council of State decided to refer the matter to the European Court of Justice for a preliminary ruling concerning the compliance of the guidelines with European law. Of course, the Council of State raised several questions, but because we don't have enough time, I will just focus on the question of whether these guidelines actually comply with European law. So now let's move to the next slide, please, whereby I'd like to present you very briefly the judgment or decision of the European Court of Justice. By claiming that these guidelines are valid and then the European Banking Authority did not exceed its competence, European Court of Justice put forward several arguments. First argument is that European legislator has spelled out in details the power of the European Banking Authority to issue guidelines. For example, European Banking Authority must carry out prior open public consultations, analyze potential costs and benefits of the proposed measure, and also to seek the opinion of different stakeholders groups in banking industry. In addition, the lawful fulfillment of these requirements can be controlled by the courts. Second argument is that national competent authorities are not obliged to comply with the guidelines, which then presents another evidence that these guidelines do not contain any hard law provision. Please, let's move to the next slides. Next argument of the European Court of Justice was that the measures that relate to the design and marketing of banking products do within the scope of the authority of the European Banking Authority, because the EBA is actually responsible for ensuring the common, uniform and consistent application of European law, and in order to achieve this objective, it may issue guidance on the prudential supervisory obligations of financial institutions by regulating their financial risk-taking. According to the European Court of Justice, these guidelines can be considered necessary for the consistent and effective application of the acts that are directly or indirectly referred to in the regulation on the European Banking Authority. And this level 1 text provides for corporate governance, which is linked, according to the European Court of Justice, to product governance. This is because the latter constitutes an additional part of risk management that should be accounted for in the former. Please, let's move to the next slide. And in this decision, European Court of Justice adopts an approach of purposive interpretation by stating that the European Banking Authority can adopt the guidelines that are aimed at clarifying not only the provisions of the Level 1 Act that are expressly mentioned in the regulation on European Banking Authority, but also other legal acts as long as they pursue the same objectives as the acts. Now, I also would like to present you very quickly the opinion of the Advocate General Bobek, so we can move to the next slide, please, which was delivered on the 15th April 2021. And actually, this opinion contradicts with the approach of the European Court of Justice. According to the Advocate General Bobek, guidelines actually go beyond being simple soft law instruments for the following reasons. First of all, the contested guidelines provide that national competent authorities and financial institutions must make every effort to comply with the guidelines. Secondly, the genuine addressee of the guidelines are the financial institutions and not national competent authorities. Thirdly, these guidelines closely resemble directives. Although they are formally addressed to the member states, their provisions are in due course meant to govern the conduct of individuals, in this case financial institutions, national financial institutions, with the latter having no choice but to apply them once opted in by national competent authorities. Fourthly, financial institutions thus become bound by these guidelines at the national level, and their compliance with these guidelines can be effectively enforced by national courts. Please, let's move to the next slide. Therefore, according to Advocate General Bobek, while these guidelines can be seen as non-binding and genuine soft law instruments at the level of European Union only, they become closely resemblant to hard law on the national level. To summarize, with regard to their genuine addressees in the form of financial institutions at the national level, the guidelines are clearly much less soft than would be the case if the focus were on the level of national competence authorities only. Now let's move to the next slide, please. I'd like to present to you very quickly the implications of the reasoning of the European Court of Justice. So, European Court of Justice in this decision upholds the fundamental distinction between hard and soft law, a distinction that is based on the existence of the legally binding force and not legal effects that this act may produce. All instruments of European Union law which are deprived from the legally binding force, according to the Article 288 of the Treaty on the Functioning of the European Union, will be immediately considered as soft law instruments, even though they may produce legal effects. So now, as you can see, this approach is actually different from the approach taken by French court in this decision. Because just to remind you, according to French court, soft law instruments may be considered as hard law instruments if they produce legal effects on the concerned individuals. Now let's please move to the next slide. Further implication of the judgment of the European Court of Justice is that even if soft law instruments are not binding, they can come under scrutiny of the European Court of Justice, similarly to all other European legal instruments such as regulations, directives, and decisions. In addition, this decision of the European Court of Justice reinforces the power of European regulatory supervisory authorities to issue soft law instruments in the sectoral area for which they are responsible. Now, please, let's move to the next slide. Once these soft law instruments are complied with by national competent authorities, they become mandatory for concerned institutions in this particular country. In other words, when national competent authorities decide to comply with the guidelines, they become legally binding on the financial institutions under its supervision. Finally, the present case also highlights the differences in the approach to soft law by French courts and European Court of Justice. While the French Council of State allows to bring an action for the annulment of those instruments of soft law that create legal effects, the European Court of Justice rejects this possibility. So to conclude my presentation and to answer the questions, do means justify the results? Yes, according to the European Court of Justice, the result does justify the means, meaning that European Banking Authority can issue soft law instruments in order to achieve the objectives which are connected directly or indirectly to the objectives stated in the European Banking Authority. And perhaps we can just move to the last slide. I'd like to thank you for your attention. And if you have any questions, please, you can contact me. Here is my email address. So thank you very much for your attention.
With that, I'd like to start. As Ellie already mentioned, I'd like to speak about the influence of AI on the regulation and supervision of insurance companies with an emphasis on the US. And I've structured my short presentation into 5, respectively 6 parts. First, I'd like to address a little bit on the relevance and practical applications of AI in the field of insurance law or insurance regulation, before I will take you all to a definition of AI. This is not, it didn't happen by accident, this is on purpose. It's only a definition of AI. As many of you know, there is no real definite and uncontested definition of AI. Then we will speak a little bit about regulatory risks and chances before we have a comparative look on the agency's approach, with 2 examples being one, the NAIC in the US and the IOPA on the European side. The 5th point will address some material aspects. I will focus in the thesis substantially, which is insurer corporate governance. And I would like to speak a little bit about challenges and solutions. And I hope that there are some inputs and insights I get in the discussion. And the presentation on the 6th point concludes with a conclusion and an outlook. When we talk about the relevance and practical applications about AI and insurance regulation, I think it is important to emphasize in the very beginning that the business of insurance ever since has been very data-driven. Just for the fact of risk assessment and risk pricing, it has always been looking at historical data and try to estimate the risks of a certain insured and what is the adequate amount of premium to be calculated to be profitable. So with the rise of technology and also then on a broader scale, AI, of course, big data analysis is an important part for insurance companies because it promises to have a lot of benefits, which we'll see in 2 further slides. I've just outlined some use cases on the bottom that you can see where insurance companies actually try to apply AI technology. This is, for example, in risk pricing and risk selection, credit risk modeling, and fraud detection is certainly a big chunk of application of an application example. And last but not least, price optimization or marketing. As I've already indicated in the beginning, when we talk about the definition of AI, it's I think important to note in the very beginning that there is no undisputed definition. I think when we divide artificial intelligence and artificial, it's quite easy to say, okay, there's something which is artificial by its meaning, but when we try to define intelligence, then the debate heats up. I don't want to, open this discussion again and try to add another analysis, another attempt to define it. I think what the European Commission tried to do to define it in its proposal for an AI regulation is very well taken. So I just copied it for you here. And I think what the bottom line of this definition really is, it is on the one hand broad and it includes further development. On the other hand, it also implies and includes actual use cases such as machine learning techniques or deep learning. Importantly, when we speak about the AI in use today, and some call it today's AI, scholars emphasize that we mostly speak about narrow AI. And narrow AI are just systems taking over specific tasks after being trained with rules and extensive data, whereas general or super AI is considered probably, without trying to define it here, as real intelligence. So they really act autonomously and gain autonomously improvements, they improve themselves, and they have a really complex intelligence-like behavior. Last but not least, black box AI, I think especially important in the context of regulatory and supervisory law, not only for insurance, but also for banking certainly, is the question, can we apply black box algorithms or black box AI, so to say, where not the applicant, but also not the designer most of times, really is sure and knows how and why the algorithm comes to certain results. When we then turn to regulatory risks and chances, in my opinion, it's worth dividing both risks and chances in macroprudential and microprudential risks. Of course, there might be maybe some other distinctions, but I think this is quite helpful. On the macroprudential side, on the risk side, you will see that scholars have raised that there may be systemic risks due to the application of AI. First, because it might lead to a lowered market robustness, then also, and this is, I think, a little bit, tying to the cyber attacks point, also cyber threats, just assume a broad, AI is used broadly in the market, and cyber threats can then, of course, become a market problem in that regard. Then also loss of trust. The trust in AI is not really high already. And then if there are some malfunctioning algorithms and some unfair or discriminatory results, this may lead to a loss of trust in certain institutions and certain insurers, but also can lead to a more market-wide loss of trust. Very important is certainly unfair treatment, and I put it in brackets, proxy discrimination. We can speak about that a little bit later, and maybe in the discussion point, but these are certainly two very important risks when it comes to AI in the insurance sector. From the gains perspective, I just want to touch on two. I think overall, as I mentioned already earlier a little bit, the insurance industry itself sees and hopes a lot of efficiency gains through improved risk management, real-time underwriting, or a better fraud detection. What do the agencies do? How do they look at it? From a US perspective, it is very important to highlight that the US is divided into 50 different regulatory systems, because the insurance regulation is not federal law. It is still and to a very broad extent state law. So there is no real unique answer when looking at the US and looking at the agency's approach. Second, the NAIC, it's the National Association of Insurance Commissioners, other than IOPA, is not a real agency. It's a private organization and composed of the insurance commissioners of, I think it is all 50 states. However, they provide some guidance on and uniform approach to the insurance regulation in the US, which is why it is worth to look at their take on AI. Importantly, they published in, I think it is 2 years ago now, in 2020, some principles which summarize as facts, so that it's fair, accountable, compliant, transparent, and secure. This approach is rather short taken. I think this publication has only 3, maximum 4 pages. On the other side, IOPA, the European authority, has a, I would say, more granular and detailed approach to AI. over the last years. Most importantly, the AI governance principles which have been published by an expert group in 2021, which has, and I think this is very interesting to see, this document has 90 pages. So 3 pages opposing to 90 pages, I think already shows that the take of both jurisdictional systems is quite differently when it comes to how detailed they actually look at it. And then you see all the principles. I think I don't have to read them out loud on the right side, what the expert group actually looked at. Now, when we look at insurer corporate governance and the challenges aligned with it, this is obviously just a snapshot of all the challenges which arise. Also from a supervisory point of view, there are a lot of aspects which can be raised. I thought for the sake of this presentation, it might be enough, and I think also sufficient to just speak about insurer corporate governance and some selected problems. When an insurance company applies some sort of AI, and as IOPA, as the European Commission rightfully pointed out, it's a family of technologies, then the compliance with regulatory laws comes into play. And as I've indicated in the risk slide already, data protection, data privacy, and anti-discrimination are 2 important and very essential topics when it comes to AI. Because AI generally, and I think obviously it differs a little bit which type of AI you apply, but generally AI lives from broad and accurate data sets. So when insurance companies use data, they have acquired themselves through their customers, or they have acquired at third-party vendors, which happens already. Then the question is really, are there any data privacy or security violations? How do they maintain data security? Also with regard to third-party vendors, how can they ensure that these third-party vendors are actually compliant with the law? Also, and I think there is the comparison between EU and California is very useful in that regard. The European or the GDPR and the California Privacy Act and the California Privacy Rights Act, they are pretty much alike, and they have a strong take on data security and data privacy. So insurance companies, especially in California, they face similar risks when it comes to the use of data than European insurance companies. With regard to anti-discrimination, as I highlighted already in this slide earlier about regulatory risks, proxy discrimination is certainly a very important point, because proxy discrimination, first off, it is important to note that when insurance companies price their premiums, they sometimes are not allowed to use certain traits. So in the US, for example, ethical or race or location, the gender, these are traits which are sometimes not allowed to use to actually price a risk. And of course, if you, for example, and this is a little bit stereotyping, but addresses the problem quite well, if you use instead of these traits geolocation, so where certain people live, especially in the US, you can already tell what kind of insured this person is probably going to be. So if you look at certain areas in San Francisco, if you look at certain areas in the Bay Area, for example, Oakland, or in LA in certain districts, you already know if you look at these locations of these insureds, then you can probably tell what kind of insured it is. So you don't need to use the race as a trait, but you can use other factors which draw back proxy, which can be used as a proxy to discriminate these people. So this is a huge problem. And a third point, and then I will move on to the next slide, is the tension between public disclosure and proprietary rights. Because especially in California, there is a full disclosure of the rate making details. So the insurance company has to really publish all its details, how it came to how it actually developed a rate, and there is no confidentiality exception in California. That means that if there are any proprietary rights involved, for example, when using an AI from a third party or in-house developed, then this maybe just be published and then loses all its value. Now, how can we address some of these issues I just raised? With regard to the last point, and I would like to draw your attention on the very last bullet point of this slide. In my opinion, California and what the California Insurance Commissioner did is not really up to date in the sense of that it does not really consider the proprietary rights and also the effects on innovation it may have if insurance companies have to publish everything they have obtained with regard to certain algorithms to the public. Also because the improved insurance or insurability, improved rate making, when we see it at least from a certain angle, increases society, the societal welfare. And this is something the regulator also wants and also seeks for. So there must be a balance. And my take on this is that it should be only a full disclosure to the regulator in terms of regulatory reporting, but only a very nuanced disclosure to the actual customer, meaning which data has been used and how did the insurance company come to a certain result. Yeah, and then I think to the first bullet point, in my opinion, and this is in line actually with the IOPA and the NAIC, but there's none specific law in California, for example. There should be specific expertise and know-how and training on management level. From an accountability point of view and a liability point of view, the management level has to be held accountable if a algorithm runs rogue or acts or violates certain laws. This leads me then, and with that I will also end my presentation, as I see I've run out of time, to the conclusion and the outlook. As of now, it seems, to be honest, that the risks and uncertainties kind of outweigh the chances. When we think about the chances of AI in the field of insurance regulation and supervision, then for me, it seems really that this is more aspirational. Also because we have a limited type of algorithm which is in place. Generally, and I think this is sometimes a little bit coming too short, because either people are very optimistic and enthusiastic or they are super critical. I think it's a basic rule, same risk, same regulation. And if there's higher risk, then it needs higher regulation. And this should be assessed case by case. In that regard, regulatory sandboxes can be an option. In the US, we have already 10 states which use regulatory sandboxes for fin and insurtech applications. California has none. And my call is that California should also include this in its legislation. Last but not least, compliance, and this has been mentioned by the ethical group of IOPA, will require not only complying with the law, but also looking at ethical standards and to comply with ethical standards. And this also requires to look at the insurer culture, as it has been mentioned already 2021 by IAIS, by the International Association of Insurance Companies, Insurance Supervisors, which is important to look at the company and to make sure that the technological change also actually is applied in the company's culture. With that, I stop. I'm sorry for pushing the time a little, and I'm looking forward to the discussion. Thank you.
So on this note, let me close this very vivid conference, I would say. All the topics were resting at the heart of the developments in the banking sector. Let me thank all the participants on behalf of the Young Researchers Group. First of all, many thanks to Anna Gordella for her intuitive keynote speech. Of course, many thanks to Ilia, Eduardo, Domina, and Lucas for their comprehensive and absorbing presentations. Of course, many special thanks to our distinguished discussants that joined us today, Professors Christos Gortsos, Matthias Hendiens, Matthias Lehmann, Filippo Annunziata, and Michael Ziri. I think your thought-provoking remarks and questions gave a unique flavor to this conference. And many thanks also to the attendees who honored us with their virtual presence today. We do hope that the next year we will be able to hold this conference with physical presence in Frankfurt, and we will be happy to welcome you all there. Before closing, let us again point that our thoughts are with the people in Ukraine, and we do hope that this situation will be over soon and that democracy will prevail. Many thanks to you all, and wishing you a very nice evening. Goodbye.